I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are going to continue on the compilation highway, and today we are on Route 106. That is right, compilation 106. And we're going to be in 4 different judges' courtrooms on today. Before I give you the rundown on those judges, don't forget to like, share, comment, subscribe. It helps the channel tremendously. It helps get these compilations out. You guys have been sharing them like crazy. So that's just been a plus and a bonus. So thank you for that. There will be no commentary added to this compilation, but there will be chapters added for your convenience. Now, let's get into the judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge Simpson out of the state of Michigan. Second, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. Third, we will be in the courtroom of Judge Suzanne Hudson out of the state of Texas. And last but not least, we will be in the courtroom of Judge Kevin Hesselink, also out of the state of Michigan. Listen, this has been a great journey. We're going to continue down this highway, and we're going to pick up speed, and we don't have to worry about being pulled over by any cops on this compilation highway. So guys, let's go ahead and continue on Route 106.
Why are we calling Mr. Harbin? I didn't call that case. He did. He said something. Mr. Drains, can you state your name, please?
I, Cartier Amani Drains, hereby declare that I am a living, breathing human being, a natural person distinct from any legal or corporate entity or fiction. I do not consent to be, I do not consent
Okay.
to be represented or binded by any assumed legal identity or straw man. I assert my full rights under natural law and constitutional protection as a sovereign individual. I stand before this court to represent myself. All legal matters pertaining to the charges brought against me. I reject any notion or claim that my person may be divided, operated or substituted by any separate legal entity. I affirm that all statements, evidence, and arguments I present are made on behalf of my living self, fully understanding my rights and responsibilities as a free individual.
Hey, you finished? All right. The court on its own motion is going to adjourn this because we're going to have an issue here. I have a feeling. I'm going to adjourn this probable cause hearing next week, August 7th, 2025. That's at 9 a.m. That is in person. He must be here so that I can hear him clearly in terms of what he wishes to say.
Yes.
Bond at this time will continue.
Thank you. I'll follow up with you. Thank you.
We will now take up Matthew Schrader on the record now in 2025 TR 1342, State of Kansas versus Matthew Kyle Schrader. Jared Regier for the state. Mr. Schrader, do you appear?
I'm here and for proper persona, sui juris, appearing specially and not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve 2 charges. Count 1, failed to register vehicle and classified non-person misdemeanor. Count 2, no proof of insurance, and class B non-person misdemeanor.
And you said these were allegedly committed when, which date, according to the document?
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
And location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive my right and present myself.
All right, is anyone making you waive your right to an attorney today by any threats or promises
No,
or any other reason?
no.
All right, and you do understand for the record that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
All right, I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney. You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count one. Fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the U.S. mail. If you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
All right. You have filed a written motion for subpoena of what documents from the Butler County
Subpoena
Sheriff?
duces tecum.
Of what?
There are many items on there, and
So you don't know what you've asked them to bring to court?
yeah, I do. I don't have it in front of me, but it's a lot of the typical things like body cam, dash camera footage.
All right. And they have filed a motion or a response to quash at least part of what you requested.
Yeah.
Right. And Destiny, do you have both his motion and the response on the file there in front of you?
I show the subpoena, Your Honor, and then I show the
Motion.
sheriff's office motion to quash.
Okay. All right. Well, we will set those for hearing if necessary, but how do you want to plead on these charges before we get to that?
Well, I feel like it wouldn't be appropriate to plea until I get the evidence and able to be informed enough to make an appropriate plea.
All right, so you're telling me you don't want to plead not guilty today, you don't want to plead anything today, is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me
I'm asking you, sir.
how much time I need?
No, I mean, how much time the whole hearing will, you anticipate will be?
20 to 30 minutes.
All right, let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena Dulcis Teacup and motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information in this before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
The written response and motion to quash does appear to be filed by Mr. Hulskamp, Your Honor.
All right, let's set a motion hearing on a Wednesday afternoon. Destiny, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but
And you do want it on an afternoon, Your Honor?
yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day.
What are you
November.
looking at? I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Schrader. Do you understand that?
Yep, sounds good to me.
All
right, if there's nothing further, let's
Your
see.
Honor, there are multiple matters still to address.
Go ahead, please.
Your Honor, as given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being set, requested, and this matter is being set over by the defense.
Speedy trial time does count towards the defense if he is asking for this motion hearing to be set and that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 OR was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by the officers for booking and processing Your bond will be set at a 3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with Deputy in Court Security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post the 3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
Oh, very well. Look for that invitation on the breakout screen. And Destiny, if you'll put that on there for Mr. Schrader, for the officer in Court Security 2.
What time? So it's November 12th?
The motions hearing is November 12th at 1:30, correct?
1:30. Okay.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just put the two of them in a breakout room.
Mr. Bishop, we have the defendant Vincent Luis Haynes. He's facing 2 charges: expired registration and failure to maintain financial responsibility, and a motion to dismiss. Mr. Haynes, can you please, there you are, Mr. Haynes, there, unmuted. All right. So, Mr. Haynes, do you wish to summarize your motions at this time?
Yes.
Go ahead, sir.
In my notice of abatement, I am asking for the court to show that it can uphold the Constitution in reference to Article 6. I am basically stating that I am a natural person. You know, I'm in the court even currently right now with my Lord and Savior Jesus Christ, and the notice of abatement just goes to the heart of the matter as to the jurisdiction, both subject matter and personal jurisdiction, and to make sure that these proceedings are done to assure equity and fairness. I realize that this court may not provide a remedy for me, and so at that point, I'm asking for adjunctive relief if that would be appropriate.
Mr. Haynes, you're using terms that are civil terms. This is a criminal court. These are Class C criminal charges, which carry a fine as their punishment. This is not a court that gives a remedy to a defendant. You are charged with a citation. You are charged with a crime based on the actions of a police officer.
Who did I offend?
No, sir, hang on. I'm not done.
Okay.
So I want to make sure you understand you're using civil terms. The rules that apply in this court are the Texas rules of criminal procedure. And those are the rules that dictate how the hearings and trials will proceed. And it is the Texas laws which grant this court jurisdiction in these matters. I'll make sure you understand that. If you wish to continue to summarize anything, you may, but I want to make sure you understand you're using civil terms. This is a criminal court.
Okay. Even in a criminal matter, ma'am, I still have a right to face my accuser. Again, that's what the abatement was about. And who accuses?
Sir, hang on a second. You haven't gotten to that point yet, because this is a first setting, and if you plead not guilty, there will be a trial. But as you've seen here tonight, many people plead no contest or are guilty. Therefore, there is an opportunity to hear and have all the accusations presented in court. You just have not gotten there yet.
Yeah, I don't understand that.
Okay, well, Mr. Bishop, does the state have any response to the abatement motion?
Yes, I'm just seeing this motion for the first time tonight, but it appears he says that the court lacks subject matter jurisdiction over this ticket, and therefore the action should be abated. And I'm summarizing that, the state's response would be that this court has jurisdiction to hear citations for traffic violations and Class C misdemeanors in the city of Dalworthington Gardens. And so it appears these tickets were all alleged to have occurred in Dalworthington Gardens, and therefore we respectfully request that the defendant's motion be denied.
Your motion for abatement or notice of abatement,
It's a notice.
your notice of abatement is filed, sir, but there's no action that this court is going to take at this time. And you have filed a motion to dismiss. Before we go into that, sir, there's a couple of things that I want to make sure to put on the record. You've been here in the Zoom courtroom tonight. At the start of court, I went over rights and options that defendants have. Did you hear those rights and options, sir?
I heard the rights and options that's pertaining to those particular defendants, yes.
Yeah, that was to every defendant set here tonight. Do you have any questions about those rights and options?
I mean, I don't understand them pertaining to me.
Well, they pertain to you because you have received a citation and you're charged with this offense. You may not agree with it and you may not like it, but they apply to you because you were in the city of Dalworthington Gardens and received these citations. So that's how they apply to you. Now, as I warned everyone at the start of court, you have the right to be represented by an attorney. And if you wish to have time to consult with an attorney, please let me know and I will give you a pass until next month's docket. Otherwise, if you do not have an attorney hired to represent you, you will be held to the same standard as if you were an attorney. So at this time, sir, do you wish to represent yourself or do you wish to have a continuance to consult with an attorney?
I'll represent myself.
Okay. All right. All right. And if you do not have any other questions about the rights or options that I went over at this time, we can proceed now to the motion to dismiss. If you wish to present that at this time, you may summarize your argument for the court at this time.
The motion to dismiss comes from the fact that I put a notice of abatement in, and I never got a response from my notice of abatement. Just basically asking the court, for its jurisdiction. You're explaining how your jurisdiction kicks in, but it's not relating to what I'm saying. I don't go by misnomers, and I seek, the honorable court to apply fairness, and equity. This court does not state whether or not this is a court of equity. You're telling me right now that this is a criminal court. You're saying that this is a criminal case, and you're not really presenting a crime that I see that would be tantamount to criminal proceedings. But again, everything is laid out in a motion to dismiss, and I feel that it is warranted because the court does lack subject matter and personal jurisdiction in this hearing.
Response from the state, Mr. Bishop?
Motion to dismiss should be overruled, Your Honor, or denied. State has jurisdiction here. This individual was using the roads or highways of the state of Texas. And by doing so, as is driving being a privilege, not a right, was bound by the laws of the state of Texas when driving. The allegation is he has violated those laws, and so this court would certainly have jurisdiction to hear those citations. I believe there are two of them. One is registration. The other one is failure to maintain financial responsibility.
Court has reviewed the written motion to dismiss, has heard the summary from the defendant, Mr. Haynes, response from
I object, Your Honor.
I'm sorry, sir, what did you say?
I said I object.
To what, sir?
Because there's no city, state, or government that should make a rule or law that abridges my right to the freedoms and the privileges of the continent or the land of the United States. I'm a natural born man.
Okay.
And
That objection, sir,
I have a constitutional right to be.
Sir, sir, I've heard the objection. Your objection is overruled. All right. Your motion to dismiss is denied at this time. The allegation in the citation which you signed states that you committed 2 violations in a location that is within the territorial limits of the city of Dalworth Gardens.
You have the actual
County,
ticket?
Sir, you need to be quiet and listen. Within Tarrant County, within the state of Texas, that establishes subject matter jurisdiction for this court to hear this matter. The court has not made any ruling in regards to guilt or innocence at this time. However, that does give the court authority to hear this case. Therefore, your motion to dismiss is denied at this time. Now,
Do you have
sir,
the actual ticket, ma'am, that I mailed back in?
I don't know if you mailed it back in or not, but I have the copy that you received notice at the time and that you signed it. And that is all that is required.
I signed it under duress as well.
All right, sir, are you ready to proceed to trial tonight on your cases?
Proceed to trial tonight?
Yes, sir. This is the contest docket. You've indicated you wish to represent yourself, and you are facing the 2 charges of expired registration.
I need
and
to have
failure
a
to
trial by
maintain-
jury, ma'am. Everything.
Okay, well, we're going to get to there. So to the charge of expired registration, how do you wish to plead, sir? Guilty, no contest, or not guilty?
I make no plea, ma'am. I'm not pleading. I do not accept your jurisdiction.
Well, that's the step to getting set for a jury trial, is if you're going to plead not guilty. Are you pleading not guilty and requesting a jury trial?
There's no plea that I'm making.
Therefore, the court will enter a plea of not guilty for you. And you've indicated you wish to have a jury trial. Is that correct, sir?
The jury trial, yes.
Okay, so enter a plea of not guilty, setting you for a jury trial. So we're going to set you for a pretrial docket, and that will be September 3rd at 7 p.m. You will get a written pretrial order. You need to read it over. It explains what you need to do and the timing. If you have any motions that you want the court to hear as far as discovery or anything of that matter, they needs to be filed at least 14 days before the court, before the pretrial hearing. If you have any evidence you wish to be able to present to the jury, you need to have that marked and filed with the court according to the pretrial order. Once we have the hearing on September 3rd, you will be scheduled for a jury trial, which we have during the day. So make sure that when you come on September 3rd, you're aware of your schedule and any conflicts that you might have for September and October.
Thank you.
You will get a written pretrial order and you'll get a reset notice. We'll see you back here on September 3rd at 7 p.m. You are released at this time unless you have any question regarding the scheduling, sir.
You say back here, this is going to be on a Zoom call again?
Yes, the pretrial will be on a Zoom call. Yes.
Okay, and I'll have instructions relating to all of this as well.
You'll get it all in writing. It'll be signed by me, and you should receive it early next week, if not earlier.
All right.
Okay. Just watch your email, check your spam folder, because there will be some attachments, so they might go to spam or junk if you have that. All right.
If I have any questions, I'll make sure I call your clerk.
Call, or you can send them in writing, either way. All right.
All right.
Okay, this concludes your hearing. You're released at this time. We'll see you back for your pretrial hearing September 3rd.
Yep.
Next case I have is Vincent Haynes. Vincent Haynes, can you unmute, please? Mr. Haynes, can you unmute, please? I can see, there you go.
Okay, sorry
Okay.
about that.
That's all right. All right, so Mr. Haynes, you have 2 cases set. We have expired registration and failure to maintain financial responsibility. And you have indicated that you wish to plead not guilty, and are you requesting a jury trial, sir?
I grant the court use of my name for future return on my equity. I say again, I grant the court use of my name for future return on my equity. Your Honor, I have to object because I never made a plea. You made that plea for me. I did not make a plea. If I make a plea, it is a plea for release. I need to make a plea for release.
Okay, so Mr. Haynes, that's not a plea that applies in this court. You're using civil law terms like this were a civil court, and it's not. This is a state-created criminal court, and as I went over with everyone here, you have three options to plead. You can plead guilty, you can plead no contest or not guilty, and by law, if you do not enter a plea in this court, then by law, I have to enter a plea of not guilty for you. I do appreciate you reminding me of that. That you indicated that it was, you're correct. I did enter that plea for you because you did not enter one of your three plea options. You are set tonight for a pretrial hearing. We sent you an order of pretrial hearing and the complaints back on August 12th, and I do not see that you filed any requested motions or requested jury charges or anything. I do see that you posted a cash bond for these charges on August 6th. Did you send in any motions or requests pursuant to the pretrial order that I issued back in August, sir?
I did not. I did not see that email. I was looking for those instructions, but I did not. I would like to make a motion to dismiss, and for lack of jurisdiction and lack of venue. I'm a natural born person, and I have a right to face my accuser. And you're telling me that there's a crime that's been committed. And I know that there's no crime against me traveling. Ma'am, I was traveling, and my right to travel should not be infringed upon.
So, Mr. Haynes, you filed a motion to dismiss that was heard in court on August 6th, and the state responded, and and that was the court ruled that that was denied. Therefore, the court does find that we do have jurisdiction for this charge, and so your criminal charges, which are Class C criminal offenses, are pending here at this time. So, other than that motion to dismiss, I do not see any other motions filed. Mr. Bishop, is there anything from the state? Any motions filed from the state? You're muted, sir. I'm sorry.
No motions from the state, Your Honor.
Okay. So, Mr. Haynes, a plea of not guilty was entered on your behalf by the court because you did not enter a plea at that time. Are you wishing to change that plea to either guilty or no contest? I need you to say yes or no out loud. I'm sorry, sir.
Ma'am, I mean, I asked, for, even in the last time we had this hearing, I asked for your jurisdiction, and you're just telling me that it's a state jurisdiction matter. And I mean, I didn't understand how, I have to understand that, and I don't understand that.
Well, sir, you are charged with failure to maintain financial responsibility and displaying an expired registration. And Texas law requires that people who operate a motor vehicle in the state of Texas obtain and maintain a certain amount of financial responsibility. Oftentimes it is insurance, but there are other ways to provide it. And that they register their vehicle every year with the state. And so you were charged with violating those charges, which are Class C charges, and you received that notice in the citation.
I signed that
Well,
ticket.
sorry, I'm not done, which was issued to you, and
Okay.
you also received notice in the complaint that was sent to you in August, on August 12th, and we can send the complaint to you again, but those are the charges, and you have received notice of that.
Okay. I'll send those charges again. But if you look at my ticket, Your Honor, I do not contract with the state. I rescind the contract pursuant to US 15.
Sir, this is not a contract, and the U.S. Code in regards to contracts does not apply to Class C misdemeanor offenses in the state of Texas. So that does not apply here.
You're conducting matters for money, and you're saying that there's a crime committed, and I just don't understand. So there are several things that I really object to. And
Okay,
like
well,
you
sir,
said,
listen, as you've heard me, because this is your second time to appear in court, you absolutely have the right to go and consult an attorney. And you may seek that attorney's advice, and you may hire someone if you wish to do so. All right, sir. But this is a Class C. These are two Class C charges. And the information in regards to that, the citation and the charges are listed on the citation that you were given a copy of, and they are listed in the complaint, and we will gladly send you another charge to that complaint, another copy of the complaint, excuse me, sir. So if we have no other pretrial motions at this time, if you do not wish to waive your right to a jury trial to have me hear your case, we need to go ahead and schedule this for a jury trial.
jury trial.
All right. So give me just a minute to look at the court's calendar. All right, Mr. Haynes and Mr. Bishop, the next available dates for jury trials would be either November 12th or November 13th. Do either of you have a known conflict to those dates at this time?
I do not.
Okay.
Your Honor, I do not. Either the 12th or the 13th of November, no.
All right, so we're going to set these for jury trial on November 13th. That's a Wednesday. I do believe that Monday is a holiday, so that will give us one additional business day beforehand. And so, Mr. Haynes, we do have our jury trials in person, so you will need to come to the court. I'm going to schedule both of you, the parties, to be here at 8:30. You will receive juror information. You will be able to conduct voir dire, which is questioning of the jury. The jury will be selected. Have any witnesses and documentation ready, because you'll have your trial that day. All witnesses and all documents, all evidence will need to be ready at that time. So let me make a notation here. So jury trial, November 13th. Parties here at 8:30 a.m. The veneer panel will be here at 9, and we'll begin the jury selection process very soon after 9 a.m. Any questions, Mr. Haynes?
Nope.
Okay, thank you very much. Watch your email. Do check your spam folder, because there will
I'll
be
have to check my
attachments.
spam. Yes, ma'am. That's
Okay.
what I have to do. I have to
Okay.
check my spam.
Okay,
That's
so
correct.
we will send you a reset notice for that setting. We'll make sure to resend the complaints. All right. If you have not received them by Monday, please call my court staff. They will resend it while they're on the phone with you to make sure you've gotten them. All right.
Yes.
Okay. All right. You're released at this time. We'll see you back here November 13th at 8:30 in the morning. Thank you.
All right, Carl Papp, that's file 25-43426-FY. I see Mr. Truce is here on behalf of Mr. Papp. Mr. Papp has been waiting patiently in the, looks like jail NCF or MCF visiting room. Is that you, Mr. Papp?
Yes, sir. I can't see you guys. Just let you know. You guys
All right,
were
I
there.
apologize. Maybe is there someone there that can assist you with that?
I'm gonna try to exit and come back in and see if that fixes it.
Thank you. All right, Mr.
All right.
Papp, can you see us now?
Yes, sir.
All right, good. Thank you very much for the assistance from the staff there. I appreciate it. This is a date and time set for a felony status conference or review. And I do see that a preliminary examination has been set for next week on the 20th. Do we have a resolution of this case?
I know I asked Judge Cooper for a dismissal because the actual victim has made it very clear I did not do this.
So hold, do not talk about the facts of the case.
Okay. The question, Mr. Papp, and I understand that Mr. Truce is here as standby counsel, that you are representing yourself, so I will address you, Mr. Papp, in person. But Mr. Truce is correct. We don't want you to make any statements that might be used against you later because we are recording this. So the question was, do we have a resolution? And I guess that was a little bit vague. I guess my better question was, is there some agreement that the prosecutor and you have reached as to how to resolve this matter?
I haven't got nothing from nobody. I haven't even got the actual court date for this in the mail yet, to be honest with you, Your Honor. But I did send certified mail. I have the tracking number for an affidavit of negligent averment. That if you guys haven't got it yet, it should be there very shortly. Because I am trying to get this dismissed, and I know Mr. Richard. I can't pronounce your last name,
Mr.
sir.
Truce. Yep.
Truce. Okay. I've tried to reach out to him. My fiance tried to call him a couple times a day because I'm not worried about something hurting me because I know I didn't do nothing wrong. But the actual victim in this case made it very clear I have not done this.
All right. Well,
So
you're going to
how-
have a chance. All right, Mr. Papp, hang on just a second. Again, I don't want you to make any statements that can be used against you later. So next week is what's set for a preliminary examination. And that is where testimony will be offered. If you want to have that hearing, testimony would be offered, and I would be able to make a decision of not whether you're guilty or not, but whether there is at least some evidence that you committed this crime. That's called probable cause. So next week is set for a preliminary examination. That is the date at which we would discuss whether or not the case is going to be dismissed or whether it's going to go forward. So that is set for, let me find the notice again in the file. That is set for March the 20th at 10:15 a.m. so that you're aware of that now, because I'm telling you, so next week, Thursday at 10:15, you would be available for preliminary examination if you want to try to resolve the case through either a dismissal or the case moving forward. Ms. Brucker, is there anything else that we can accomplish today?
I'm just looking at the calendar. Mr. Truce, as your standby counsel, it looks like you and Mr. Rolla might be in trial next Thursday. Is that correct?
It is. Yes, I am scheduled to be in a trial next Thursday. Also, I was notified that this court's docket for next Thursday was all adjourned because of a scheduling conflict with another trial in the district court.
We are going to be filing a stipulation in order to adjourn that trial.
Okay.
I know.
Is that the case we talked about yesterday, Ms. Brucker?
Yes.
All right. So yeah, it sounds like with that problem has been resolved. So are you going to be available, Mr. Truce, or not?
That is an interesting question. So I filed a motion in limine on the jury trial that I have scheduled for that date yesterday in regards to a witness disclosure issue. I proposed two different resolutions to the circuit court judge, one of which being that he limit the prosecutor to the witnesses they actually identified on their witness list. The other being that he continued the trial to allow me to investigate the additional witnesses. I have not heard back from the circuit court judge as to how he intends to proceed.
So I assume that's a circuit court trial. Is it a one-day trial, a multi-day trial, or what is it?
It is a one-day trial.
All right, but it's still scheduled to go as of today.
Correct.
All right. Are you available on the 21st? Excuse me, no, it would be the 27th. we have room on the 27th, Mr. Horgan?
Right now. So yes, I am available on both the 21st and the 27th.
If we go to a preliminary, I'm sorry, Mr. Papp, go ahead.
I have court on the 21st at 10 o'clock in the morning.
And what case is that for?
It's a CPS case because they're using this to try to take my son from me.
Okay. I assume that if we go on this case, it's going to take even the preliminary examination is going to take a little bit of time. Ms. Brucker, how long do you anticipate we would need for a contested preliminary examination?
I'd say at least, I'm just kind of guessing on this, at least 2 hours.
We probably don't have that available on the 27th.
We do not.
How about the 28th, which would be, Mr. Papp's not available on the 21st, so I'm checking to see.
My bad. I read my thing wrong. It's the 27th, unless I have it wrote down wrong. So 21st is good for me.
All right, either the 21st or the 28th.
I apologize.
Nothing on the 21st. You've got one hearing on the 28th at 10 o'clock.
Ms. Brucker, are you available on the 21st? That's a Friday. We would have 2 hours, a little longer time period to put things in there.
I think that will work because I think Mr. Rolla may want to handle this, and I think he's available that day.
All right, Mr. Truce, does the 21st, not this Friday, but next Friday, fit your schedule?
Yes, Your Honor.
All right, what time do we have? Go ahead, Mr. Papp.
I asked Judge Cooper, he denied me. I've been asking for the bill of particulars for this very case, and I've yet to receive them. He actually denied me, told me, no, I cannot have them, which is a violation of my constitutional right.
Well, you have to make your requests in writing so that we have them and can study them and understand exactly what you're asking for. And if you want to do that, you're going to need to send it in a copy to the court, a copy to the prosecutor, and a copy to Mr. Truce. Anything that has to be filed with the court, any motions that are made with the court have to be in writing so that we can understand them and study them prior to making any decisions on them so that we get those decisions right. So you're certainly entitled to do that. You can make whatever motions you want to make, but you need to do those in writing and send them to the parties that I've indicated. All right, we're going to set this matter.
Is it all under the same address? Excuse me, I'm sorry, Your Honor. Is it all under the same address besides Mr. Truce?
Mr. Papp, I will send you the address for everybody.
All right, Mr. Truce will assist you with that. So we are going to set this matter for a contested preliminary examination. We'll adjourn it from the 20th to the 21st so that we have more time to allow Mr. Papp to make a clear record of what it is that he wants to make a record for. And so we'll send that out. I find that 1 day adjournment is not a significant time problem, and it does allow us to have Mr. Truce present, and it would allow us to have much more time than we would have available on the 20th to make a full and fair record for Mr. Papp. So Mr. Papp, you're going to get a notice from the court indicating that the 21st is the date. Most likely it will be in the morning. And then we'll send that out to counsel as well. Anything else, Ms. Brucker?
Do we have an idea of the time? Just because if we're doing a writ for him, I'd like them to get that going quickly.
9 o'clock.
We do 9 o'clock. Truce is available.
Mr. Truce, are you available at 9?
Absolutely.
Let's just schedule it right now for the 21st at 9 o'clock.
Is this in person?
Yes.
Okay.
So, Mr. Papp, you will be receiving some documentation indicating that the next court hearing is on the 21st at 9 a.m. The prosecutor was just talking about a writ. That's the paperwork that's used to make sure that you're here in person for that, and you'll have a chance to then discuss the matter with Mr. Truce in person rather than trying to do it electronically in breakout rooms. And I think that will proceed much easier for everybody if necessary. All right, so I'll see you all on the 21st at 9 a.m. Thank you very much. That's all for today.
Mr. Papp, You're going to
Yes,
get
sir.
a request. You need to approve me as a visitor for you so we can do video visits. Also through
Yes, sir.
JPay, you're going to need to accept that as well so I can send you emails.
Yes, sir. Yeah. If you get, I have JPay stamps. So if you JPay me right now, I could write you right back right now. And then I haven't got no pay. My paperwork last mail I got has been, they take weeks to give it to me for some reason.
It's
But I would
not
love to
going to happen
communicate
right
with you.
now, but you
Yeah.
will get communication from me.
Yes, sir. Thank you. Greatly appreciate it. And thank you, Your Honor.
You're welcome.
I'm not threatening you. Say one more word and that's 30 days. 30 days.